Hello, everyone. It's Philip. We're going to go over the exclusive right to sell listing agreement, and we're going to go line by line. It is a 5-page agreement, and we'll highlight the changes that were made and explain the different segments of this agreement. So number one is pretty simple. It is the property address, and you put the property address on that line. Legal description, you can highlight it from the county website and add it there, or you could actually attach it if it's a very long description. It's important we know exactly what property we are listing. Secondly, it's the agreement. So in consideration of the agreement for Key Realty to market the seller's property and use its best efforts to find a realtor, sellers agree to give us the exclusive right for this time period to sell their property starting on, and that is the list date, and expiring through. So however months would go in there, that's the start date and the end date. In consideration of this exclusive right, we agree to use our reasonable efforts to sell the property and present the property to other realtors, companies through the multiple listing service, and engage in marketing efforts to expose the property. The effective date of this agreement is either indicated the date of the agreement right there, or the date they sign it. So this is important to understand. What happens is if you say you sent it to them on a Tuesday and they didn't sign it till Thursday. So Thursday would actually be the date you would enter into the multiple listing service, and that is the start of the contract. Okay. 3, price and terms. That is the amount of money they're listing the property for, goes on that line, or other such terms and conditions the seller may agree to in writing. So what number 3 says, basically that is the list price, but if there is a change in price or terms, it will all be done in writing. Okay. Number 4 is compensation. Now, this is the change from the past where it used to have a total commission in there, what we also paid a cooperating broker. So that's no longer in there. So the only commission we're talking about in this compensation is the compensation they're paying the Key Realty and the listing company for successfully selling their property. So it's Key Realty and the listing agent, to clarify. So if during the term of this listing, we produce a buyer who is ready, willing, and able to purchase the property at that listed price or other terms they agree to exchange in writing, they agree to pay us a commission equal to, and that is where you put your commission amount, and the sale of the property plus a dollar amount. So that is an optional, but if you charge a transaction fee, that is where the transaction fee would go. And it goes on to say, under no circumstances would the above commission be less than. So this would be where a minimum commission may kick in. So if a minimum commission of, say, $3,000 or $3,200, that's where that number would go in there. So it's a very low price property. That is where you would put your minimum commission. In the event the listing agent procures the buyer, and this is a change, in the event the listing agent procures the buyer, basically you're double dipping the property, the total commission will be equal to, and that's where you put the percentage of the price, and then if there is a transaction fee would go in that last line. So what this is saying is that if you listed the properties for 4%, but you bring the buyer and you say you want to charge an additional 1%, then that would be the total commission on that line would be 5%. Okay. And that's for the sale, you double dipping the property. Okay. So that's what goes on that line. Furthermore, goes on to explain, and this is the protection period. If after the expiration of the agreement, they sell or trade anyone we brought to the property during that 12-month period, they would owe us that commission. So that's the protection period. And then it also goes on to state that it is agreed if they do indeed, if it's sold through Key, that we are authorized to represent and receive compensations from both parties of the transaction. So they understand we're going to be buyer's agents, and that buyer agent could be paid by their buyer. And it also goes on to remind them that all commissions are negotiable. That's the last line item in number 4. So basically you're going to do all your services, and that's the list side. Number 5 is an optional section. Although many multiple listing services are adding in the multiple listing service whether the seller wants to pay buyer concessions. which is completely legal. We've done buyer's concessions for years. We used to do buyer concessions when interest rates were very high and buyers used to offer to pay points to lower their amount. This is where sellers offering to pay some kind of additional monies to help a buyer acquire the property. So they're basically financing their costs, their acquisition costs. So starts out number 5, seller does or does not authorize the brokerage firm, that's key, to advise potential buyers and their agents through the multiple listing service that they're willing to consider concessions. And this is optional. It's just that, hey, they would consider concessions is the first thing that's there. And this invitation is contingent upon all other terms of the offer being acceptable to the seller in their sole discretion. So even if they say, yes, we'd consider paying concessions, it doesn't make it mandatory. It would only be if it's part of the negotiations and in the purchase agreement. The next line is the seller is willing to offer the following towards the buyer's concessions. So either a percentage or a dollar amount. We will give you further. We could talk for a half hour on this issue. We'll give you further advice on how to move forward. That a little bit will depend a little bit on market and price ranges, etc. In your feeling for the seller. So it'd really be one of these things. Does the seller want to offer buyer concessions, yes or no? And then do they want to offer an amount? And they are optional. Number 6, additional offers to purchase. So this is the line that are we going to present additional offers after they have an accepted offer? Many markets, once they have the property done, it's up to the seller whether they want us to if there's any other offers written after their acceptance, why it's pending or contingent, whether they want those to be presented or not. And then either they agree that we will not present them, or they disagree and they do want to see all offers. So if they don't want to see them, it's agree. If they want to see them, it's they disagree. Okay. So they have to affirm one way or the other. All right. So number 7 addresses the year built in the lead-based paint disclosure. This is the compliance with lead-based paint, whether it was built prior to 1978 or later. Was it built or represents that the property was built before 1978, whether the law affects or not. So they're warranting that for us. And then it goes through the required seller questions. They have to provide the buyer with a federally approved lead-based paint appellant, which we're going to do. They're going to disclose whether they know of any presence of lead-based paint or lead hazards. They're also going to provide the key and the buyers any information they may have if they do have any reports. They're also going to provide the buyer a 10-day opportunity if they want. If the buyer wants that 10-day opportunity to inspect. And finally, any contract for sale of property will include the attached lead-based paint warning statement as purpose of the law. So it's just that they're going to comply with that, and you go through that with them. All right. Number 9, buyer letters. So our position is that we do not permit and submit what you sometimes call buyer letters or love letters, basically due to fair housing risk. We're not going to submit, review, and have any personal information, photographs, etc., from the buyer to the seller. And they understand that it's the risk involved for fair housing, and in most attorneys, boards, etc. Just it's very it opens up a lot of exposure to not only the brokerage but really to the sellers on why they made their decision, what was it based on, and that's why we don't do that when you have that conversation with them. Number 10, that the seller does authorize us to put a lockbox on the property and permit showings of the property by other licensed professionals, real estate licensees, to enable service provider perform services in conjunction with the sale. So sellers shall not disclose any confidential information to any other real estate licensees. We remind them that those are buyers' agents. Also, is there a lockbox, what the code is, or is there an electric lockbox used, electronic? It's just they're giving us permission to let other agents through, and we do remind them at that point not to share confidential information as they would be buyers' agents. The fixtures and equipment, this is really, it's not all-inclusive, guys, but this is just go through here carefully what stays and doesn't stay with the property. There are certain things, everything from security systems, whether they're owned or not. We've had some things that are rented fuel tanks, whether it's rented, whether this, just carefully go through each of the things, whether it stays or not. And the sellers are also going to include, that's something that's not addressed there. And then the exclusions go on this next line. Please remember, just because they exclude on the listing agreement, ultimately what makes the decision though is the purchase agreement. So you'd want to make sure and address it on the purchase agreement. Number 12, home warranty. They acknowledge the availability and benefits of the home warranty plan. They also acknowledge that we may be compensated for performing certain tasks with that home warranty plan. They're also referencing that we're going to give them a copy of the APHW home warranty agreement. And yes, they would like a home protection plan through America's Preferred Home Warranty with the coverage beginning on the date, or no, they're waiving that warranty. You need to give them the agreement, have them sign the agreement, and explain the advantages of this. Many sellers like the fact that their home is covered during that warranty period, and they like the fact that it reduces their liability, as there is additional benefits, not just covering things for the buyers after they purchase a home, but also some reduces their liability, and they actually, depending on which warranty they buy, will have some coverage for attorneys writing letters on their behalf. Make sure you understand it and explain it to them. Showing and signs, we may photograph, gives us permission to photograph the property and publish the pictures, advertise availability of the property through any medium, websites, Facebook, etc., place a for sale sign on the property and remove other for sale signs if there are, and also show the property at reasonable hours. They acknowledge the use of certain advertising results in contents of the property being made known to third parties and contents of such advertising. So they're agreeing that yes, if they don't want something to be shown that they have in their property, they need to remove it, because if we take pictures, those pictures are going to be published. So have that conversation with them on 13. Fair housing, the sellers and brokers shall comply with all federal, state, local fair housing laws. Guys, explain them exactly what this means. And we never show nor advertise houses based on any of the protected classes. This is something we are totally committed to, and make sure you have the conversation with them. Block busting. It's also illegal to profit from or induce or attempt to induce a person to sell or rent a dwelling based on entry in the neighborhood of people belonging to a certain protected class. It's a sad history in the real estate industry. It needs to be addressed, especially in Ohio. Actually, explicitly has to say that, but we make it perfectly clear in the contract. Title and taxes. It's the sellers represent that they have clear title to the property and is good marketable title. They will execute and deliver a warranty deed, land contract, or other instruments of signed conveyance shall be required to release dower with all the delinquent taxes and assessments paid. They agree to on a subsequent purchase agreement, they'll furnish proper evidence of title to the buyer and inform them of how we're going to prorate taxes, and that will all be driven of what is on the purchase agreement. It does change market to market, so it's driven by what's on the purchase agreement. They understand that they have the right to counsel and choosing connection of their agreement, their buy-sell agreement, and they should use attorneys if that's what if they want further information about that. Referrals, number 17. Sellers agree to refer Key Realty all inquiries received about the property or listing agreement. So if someone knocks on the door, someone offers to purchase their house, they agree to refer those to us as an exclusive right to market the property during that time period, that they would send those leads to us. 18, that we do participate in multiple listing services, and it will be listed in there, and a copy, with the copy agreement, any changes, post-closing information is provided there, including the sale price, and photos of property will also be syndicated through their websites, including Zillow, Realtor.com, ListHub. So they do understand, once it's a multiple listing service, that is going to be spread out to other websites from there, and they're giving permission to do that. Number 19 is to address with foreign sellers. So on foreign sellers, they need to provide U.S. taxpayer identification number prior to the closing. The application could take some time, 4 to 6 weeks. Failure to do this could delay the closing. If they're not U.S. citizens or permanent residents, There are certain things that have to be done with guaranteeing that the taxes are paid, and money sometimes has to be held in escrow depending on the price of the property and the circumstance. If you have a foreign seller, this is where you really need to address it then get your broker involved in, or a title company, of exactly what they'll need so it will not delay the closing. Okay, as much as anything, it's a cautionary, right? It's explain this because what can happen, and this is the act. And the act changes a little bit, so it's need to get someone involved that understands how it would affect them. Heirs, this agreement shall be binding on heirs, personal representative, administrator, executor, assigns their successor or seller, so if something happens to them, it actually continues the listing along. 21, indemnification. And what this is really talking about, this is what protects us, and they're going to indemnify or hold us harmless or release us, our cooperating agents, brokers and agents, from any liability, attorney fees, etc. Personal property damage, the use of video surveillance to gain access to the property, lockbox failure to comply with any of the disclosures. They have to disclose that if they're using those things. And basically, guys, this is to cover us in our liability, right? If we use our best, efforts, and we use reasonable care, it's to protect us from any liability in them claiming we didn't, based on things they may have told us, limit their ownership, dimensions, statement of age, or anything we've relied on them. We're protected if they've misled us. Okay. Representations, the sellers represent and acknowledge that Key Realty is relying on representations, whether oral or written, made by sellers with respect to the property. They warrant that these representations are true, and the listing agent is authorized to make those representations to buyers. So it's basically, if they say, listen, I put the roof on last year, that we're going to take their word for that. Or we've never had water in the last 5 years, we're taking our word for that. They're allowing us to pass that on to buyers, but it takes us out of the loop. We're relying on those representations that they were true. Okay. Unsupervised access, they understand the addition of real estate agents, sometimes licensed and certified appraisers, home inspectors, contractors, or other professionals may have the privilege to use the lockbox of the multiple listing service. They also agree that they can access without a real estate agent, but really how this goes on to say, the seller's going to be notified in advance, and that these people are entering. So you're basically understanding it's not just necessarily a real estate agent, but it could be other professionals, and they understand that. And they also are letting on the last line, the sellers agree that the buyers may attend appointments with the authorized individuals. So if they're going to come in there with their inspector, we're going to let them know that, and we're going to explain that up front on how that works. Okay, so that's 23. 24, video surveillance. Sellers understand that under certain state laws, that sellers may use electronic, mechanical, or other listening devices to record otherwise contents. Okay, so basically what this is saying is that it's explaining the video surveillance law. If these devices are being used on a property, they're going to turn them off during the time that the people are in the property. So they're not supposed to be recording these things. They need to be notified, and applies to all showings, open houses, other appointments for buyers, real estate license, that the seller is advised to consult with the attorney regarding such use of these devices, and that they're actually agreeing to turn them off during showings. Okay. Residential property disclosure, the sellers agree to provide the buyers with a completed residential property disclosure under the state laws, unless the transaction is exempt by those state laws, and they agree they're not going to provide any advice in completing these. So they're filling these things out truthfully and honestly, and they didn't rely on us to fill it out for them or tell them what to put in the different blanks. That's what that is saying. And if it is that they're agreeing to fill that out. Limitations, number 26, the sellers of Key Realty agree that any claims and lawsuits between the parties regarding to this agreement must be filed no more than 6 months after the date of termination of this agreement. The parties waive any statute of limitations to the contrary. So basically, if there's an issue, the issue has to be brought up within 6 months of the property. Not coming back on a 2-year statute of limitation. they're agreeing that it would be limited to 6 months. 27, clear cooperation. So this rule didn't change. So once a property is put into multiple listing service, or once it's listed within 1 business day of marketing the property to the public, the listing broker must submit the listing in the multiple listing service. So guys, no advertising a property unless it's actually listed. You have 24 hours from when it is listed to start in advertising the property. Once it starts advertising, you trigger the 24-hour rule that it must be entered into multiple listing service. So even if your MLS says you have 3 days to put it in, but as soon as you start advertising the property, as soon as anyone starts advertising the property, it must be put in within 24 hours or fines come into effect. And depending on the board, those fines can be fairly substantial. And it's even if the seller starts advertising the property. Okay. 28, basically they agree that any of the amendments of this will be done in writing. Also that it can be done in fax or electronic copies is the same as writing. Okay. And they understand that even those electronic writing initials, etc., are still binding as if it was in handwriting. That is 28. 29, broker's remedies. In the event that the seller terminates his agreement for the expiration date, basically the sellers agree to reimburse us for any expenses, including but not limited to advertising costs, etc. Basically, this gives us a way to protect ourselves. Also, the broker is going to provide a list of expenses to sellers within 5 days. And so if they want to terminate, they just can't walk away from the agreement. There are limitations of what they can do, and we have to agree to these things. And it talks about what those things are. And if there is, and how that would agree with us. Because if you're in a situation where you're going to terminate an agreement, you really need to get your manager involved in how we go forward with that. Basically, the manager's got to agree to. Disclosure of information. The sellers also acknowledge and agree that the price, terms, and other details with respect to the closed sale of this property are not confidential and will be disclosed to realtors that participate in multiple listing service. So what they're saying is once it closes, that closing information is going to be published in multiple listing service. For the course of our normal business, obviously, is producing CMAs. But they have to agree to it, and that's why it's in there. Vacant home disclosure. Should the property become vacant, it's either vacant or vacant during the listing period, sellers agree to carry sufficient insurance to cover losses of any kind that may occur to the vacant property. In addition, they acknowledge that Key Realty's agents are not presumed responsible for checking and performing, verify that the home is secure. We strongly recommend that the property should, if it's vacant, comes during winter months, that it be winterized, and they should have the home winterized by a plumber that knows what they're doing in case it loses its heat source and the pipes freeze. Basically, what this is saying, they need to make sure the house is insured that it's vacant. We're not responsible for it during that time period, and pipes can freeze when it's cold enough very quickly, and they need to make sure that happens, or there could be substantial results, and we don't check in to make sure that doesn't happen. Okay. So you're just putting them on notice of that. It's obviously covering in the past things that have happened to us where they blamed us for not getting it winterized. So we're making it perfectly clear. 32 guys, wire fraud. Okay. We're never going to, you have to talk to them. They have to confirm wire instructions with the title companies directly by phone. They have to verify it to the title company or visit them in person. They should never wire funds without verifying the information. We will never, ever send wire information to them. They're never going to get that through text, mail, email, social media messaging. Nothing that's not secure, confidential should they be sending anything, nor will we send it that way either. They really need to double check all of this. This is on the listing agreements, on the purchase agreement, it's on the other agreements too. Is just really hundreds and thousands of dollars go away. We can give actual examples. There's millions of dollars that have been defrauded people through wire instructions. And we make it perfectly clear. Guys, if something's in bold and in big letters, you need to make sure they understand this, okay? And if they do see something that appears to be from Key Realty, they should not respond to it. Contact us immediately, okay? And they actually acknowledge that we've explained this to them. And if they do have an issue, they should call us right away before they transfer any information to anyone. 33 is the cancellation. This agreement can be canceled or revoked only by the mutual consent of parties in writing, so they can't just back out of this contract. It does have to have a cancellation, needs to be signed, and we have to have a agreement to either A, withdraw the listing if we don't want to cancel the agreement, but no more showings, or B, terminate the listing, and it would have to be agreed in writing. You need to explain that to them, that this is an exclusive right to sell during that time period. 34, acknowledgement. The contract contained in the terms in accordance with the conditions of the parties. There's no oral representations except what's in writing here. And they acknowledge receive this contract. You are given a copy. And this agreement consists of the entire agreement between the parties. And the signatures show that, and it may be signed in any number of counterparts. So when you really only have that is if you have more than one person sign. Sometimes a divorce, they sign them separately. Sometimes with estates, with multiple people, inherit heirs, that they could be signed in separate agreements. They're merged into one agreement. And others would just be something else that needs to be addressed in the contract. Maybe if something's included, they can sell the additional acreage for a certain amount of money, something that needs to be addressed in the purchase, in the terms that maybe it's not going to be listed online. Maybe it's anything that you've agreed to that's not addressed in this agreement must be in writing, okay? And that's where we go. Honestly, as extensive as this listing contract is, there's very few others that are added in here, okay? The seller will sign, they'll print their name, different spots. Remember, if they're married, they need to sign to sell. The emails and phone numbers are here. The listing agents puts their signature there and their information there. Each of the pages, if you've noticed, there's 5 pages. On the bottom of each of the pages, the sellers must initial. Now, this is for a reason where we've had, so you'll see it on each of the pages. There's a reason, and I know we put it on the 5th page to be consistent, but there's a reason for that, where we've had actually sellers try to substitute different pages to it, or say, I never saw that. How do I know you didn't substitute a page? Rarely happens, guys, but we want them to make sure that they understood everything and that they have a full understanding of this. So I hope that this was helpful. Have a wonderful day.